Hello, and welcome to the Communicators, a new interview series by Parisi, where we chat with expert witnesses to tackle one big question: what makes an effective communicator? I'm Nick Connor, and this week we're thrilled to have Ellen Keenan-O'Malley, a senior associate solicitor at EIP, the intellectual property firm specializing in high-value, complex patents, to help answer that question. Hi, Ellen.
Hello, thank you so much for having me. I'm very excited.
Well, as you know, AI is changing the world. It will soon, if not already possible, for AI to create a Hollywood film or a top 10 club anthem. We know AI draws on information from libraries and basically adopts existing content to create something new. So who owns that content? Does an actor own their own voice? Does a brand own its own music? How different does something have to be to stop AI just ripping them off?
Well, that question in itself is a very complex one, and there's lots of different layers to it. And so I suppose sort of distinguishing it from whether it's the copyright itself. So, a singer itself, if they write their song, then obviously they've got copyright in that. But then it could be that they've sold the rights to that to their, their management company and things like that, or they might write the lyrics for a singer and then they acquire the rights. So that's a separate point. But in the context of AI, again, it is quite a complex matter, and obviously right now it's a very hot topic in the media. We've just had the UK consultation finish, and it's sort of talking about this topic, balancing between AI and copyright holders and their protections. But the question I suppose you're asking is, how do you stop? How can the copyright holder, the singer, who's written their number one hit for, let's say, Taylor Swift, the question is, how can you get that? How can you stop AI? Right now, you probably can do so through the courts, because right now the law itself is in a state of fluctuation, a little bit of ambiguity, and although we would like to say that the law is very clear, you need consent to use someone's copyright. Certain jurisdictions have exceptions. You see in the US you've got fair use, whereas you've got in the UK it's very clear that you cannot use someone's data for commercial purposes. There are exceptions, but it's not for this general use. There are temporary copies, and some argue that that's fair game for AI training. But generally, it is in order to protect yourselves from your data being scraped on the internet. It's quite difficult, and that's probably why you're seeing big companies getting sued or bringing lawsuits like Thomson Reuters, because they've got deep pockets, or like the Getty Images case. The likes of a small artist being able to stop an AI company from using their data to train their models, it's a little bit harder. And I think that's why we're seeing people being like, right, does the law need to change to address AI? Because when all of the copyright legislation globally was written, it didn't have this in mind. So I haven't answered your question, because it is really complex, unfortunately, and it's not straightforward.
No, and it's fascinating. There's so many ways we could take this conversation, and I've got like 20 million things going in my head now as I want to ask. I think in a minute maybe let's talk about sort of training, because that's quite interesting, and using sort of data on that. But just to stick with the Hollywood at the moment, I noticed some big Hollywood stars are putting AI clauses in their contracts when they do sort of films and things. And I guess that's similar to how historically sports stars have put image rights, so they can monetize their image when they're playing a football or a rugby game or something like that. And I guess it's the same. It's because they can monetize it. So I guess if you're a business, you're a businessman, you're a marketing director, you might be a small firm listening to this and sort of, well, how can I use, Jennifer Anderson's voice, or do I just have to wait and find an artist who's passed away and maybe use Sean Connery to do my, LinkedIn advert?
Yes, ultimately, and there's nothing wrong with that. I think that's just the right thing to do. I think there shouldn't be a shortcut. Why should you be able to use somebody else's voice without their permission? And I really am quite strong about that. I don't think that it should be fair game for the advancements of technology. They can advance technology without infringing someone's copyright. And why shouldn't you pay? And we have AI companies that work for us who are our clients, and they have absolutely no issue with entering into a license agreement. They think that's the right thing to do. It ensures that they're getting high quality data for their company, and that's what's really important. So people saying I should have access to this, well, nothing in life comes for free, and AI should not be any different. And I think that there is a talent and a skill in acting, and they should get compensation for that. So yes, right now the current law is that you need a license. I don't see anything wrong with that, and I would be as an IP lawyer very upset to know that has then changed in any way, that they loosen the rights for the right holder in any way.
Yeah, no, and it is really interesting to think about, who owns something. If you right now, we're gonna put this podcast up, and your voice, your image is gonna be on this podcast, but it'll be all the pre-C sort of LinkedIn followership. But ultimately, you're the person who owns yourself, and you're letting us use your content. So I guess in a way, AI hasn't changed anything. I mean, there's no AI being used to make this. We're still using those principles. So from a matter of law, has AI changed it, or we just have to look at things, how you have done for years legally, and adapt it to this new tool, which is AI?
So I suppose it's a bit of both. I think AI has changed things in the sense that we're seeing a rise of deepfakes, which is a huge concern. And that's not just an IP issue, that is a cybersecurity issue, it's a privacy issue, it's got various layers. And I think that is what we're seeing as the negative side of things. And it is a concern. And I don't think that perhaps the current law is robust enough to address that evolution. And deepfakes is identity theft, and I think that's a distinction between the rights of the copyright holders works, because that's more a privacy issue. Because people's I was told a very sad story recently that a young 16-year-old girl has had her photo taken and put onto inappropriate images. Now that's the side of AI that we're seeing in a dangerous way, and I think that's a bit that the law, we've obviously got the Safety Act, we've got other things like that, and we've got criminal sanctions. But I think that's the evolution with AI that we perhaps haven't had before, that is definitely on the rise.
So what's the difference between, and let's take it away from inappropriate images, but it's that's basically the question I'm asking, but let's not use it as an example. Let's say if I took a AI, ask AI to do a fake podcast of this, and it drew on you there. But what's the difference between an artist sort of doing a comic book, taking your sort of image and personalities and adapting it in a art form?
It depends. So it might not be copyright infringement because if you've done it like in a pastiche, so if you do it like in a commentary way, if you do something that makes a new piece of work, new art, then potentially it would actually prove protection and it would be an exception under the Copyright Act, and therefore, you know, you've got a new piece of work that you've got protection in. So it depends, and I think that's what I know. Lawyers don't. People get really annoyed when lawyers say that, but I do think that copyright is a very complex area, and it's not a straightforward answer a lot of the time. So I, for example, even saw on LinkedIn, they basically, I done like had a recording like this, and somebody had put it up on they posted it, and then the AI tool on LinkedIn had basically populated an AI version of what I'd said so that other people could then use. And I was like, I didn't consent to my content being used to train that tool to then basically give like a default AI answer to a generic question. And I suppose it's that line that like, well, I've actually agreed, I'm on LinkedIn, sort of opted in for them to do whatever they want with my data. And it's just it's quite complex.
Yeah, and maybe, you know, let's look at examples in the music industry. Well, last night, I'm a geek and I do like music. I was watching a documentary about the origins of jungle music, and you know, and they were talking about sampling and you know how they brought in these classic reggae tracks and put stuff over on. And I guess, you know, in some ways AI is doing what DJs in the 90s, late 80s were doing. You know, they were sampling music, other people's music, and adapting that. So how is there a distinction between, in the eyes of the law, between a DJ using different records to make a new piece of record and AI picking up bits? Or is AI just taking it to another level where we probably need to rethink how the law sees this?
Yes, I think it's a good question. And you know, we've obviously got the Ed Sheeran case, that, you know, he was accused of using a riff from, you know, well-known piece of music. And often, I think in music, for example, there is only a certain number of like chords and keys, and there's only a certain number of keys on a piano, for example, and it's the same in various other musical instruments. So there's a limitation on how many variations you can have. But I think it's all about the originality. And that's really important for people to understand, that if you can prove the originality, then it's not copying. With AI, it's obviously not been trained on independent thought. It is obviously used someone else's data to train it in order for it to have the output it's got. And so there is clear copying. But it's, in terms of the law itself, there are, especially under English law, you've got computer generated works, which is actually a separate right. And it's got a different type of protection. It's 50 years rather than the life of the author plus 70 years. But the difference is that it mustn't have any human involvement. But the problem is it's slightly unclear how that would actually work in practice. How do you enforce it, or how do you even demonstrate that it's computer generated works? So I suppose there's some questions in the consultation right now around how that should be evolved, whether it would be useful in now the evolution of AI. I personally think that this is actually now when that piece of legislation is going to come into its own. And if we could clarify it, I think that would be really important. But I think, coming back to your original example of DJs and sampling, there is original art form in there. They've done something different. They've used their talent. And I think that's really important, is whether it's something a new, you know, obviously in the US it's transformative, but it's similar in, you know, it's a little bit narrower under English law, but ultimately if it's a new work, you've created something new and you can show that very clearly that you haven't copied, then there is an argument that it's a new work and that deserves a new, like, its own protection. But AI, I think it's really hard to say that it is a new work and it's not been copied. I think that to me is one of the big things, that the hurdles for an AI developer to say. But equally, they are going on. The output is often something very different, and that's the problem. Then the copyright holder can't, based on the output itself, tell whether their data was used within the training. So that's where the issue is coming. Is like, how can you prove that your copyright was used? And obviously with Getty Images, the watermark was there. There's easy for some people because you can actually trace through to tell your works have been used. But for some people, like a singer, it might not be the way to do it. I mean, some people, what they do is they'll put like typos in a sentence, and therefore if you then obviously copy and paste it, then it's clear evidence that it's been copied. But in response to your question, it is ultimately about whether it's a new work, and you can say that.
And I have to say, I always use that typo in everything I do. No excuse. So I'm quite interested, because you're talking about when you show and use publicly that information, that's when you get those copyright things. But if you didn't show and it was, how does the law interpret things for, let's call it, one, personal use? So playing around with the actor's voice and a movie scene, and you're never shown it to anyone apart from yourself. But then let's maybe take it a bit more deep into AI and saying, well, what about if you're using it to train a model? And it's probably worth just sort of giving background. The way AI is used is different from other data points under GDPR. So my GDPR, I have to opt in to give my consent for a company to use my data. But currently with AI, it's an opt out. I was looking at the terms and conditions from some of the big tech when they sent it over to me recently, and the thing is that you have to opt out of them using your data. And I guess that's the same. And the question, I'm guessing this is the same for musicians and things like that. They have to opt out from allowing companies to use that data.
Yes, it depends on the terms and conditions. It might, there isn't an automatic right that you opt out, so it just depends. So I have copyright automatically under English law, which isn't the same internationally. But the minute I put something in writing, technically, even if I didn't share it with anyone, I have copyright in it, and nobody. And the question is if somebody had access to it in order to be able to then know about it and copy it. But I suppose in terms of opting out, it depends on the company. So, for example, LinkedIn, there was a bit of a hoo-ha a little while ago, because they had basically said that you would have to expressly opt out for your data being used to train their AI models. Now, everyone was like, whoa, 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 how dare you do that? I didn't consent to that. That's not what I signed up to for LinkedIn. But then they withdrew that, and they said, oh, Europe and the UK. I think that was a mistake because of Brexit. They forgot that UK wasn't technically part of the EU. So I forgive LinkedIn for that one. But it's an interesting point, because the onus was on me to go and check my terms and conditions and see whether they'd updated them. And that's the same with like Meta. They've done a similar thing. And there's various other platforms. But generally, it's a question of the copyright holder basically saying, I'm fine with my data not, I'm fine with it being used, or there is a licensing agreement. It shouldn't be that the default is that they've got the right to use your data. But you're right. If you're I think the thing to remember is, if you're accessing a platform, then under those terms and conditions, their fair game is their view to basically choose how they draft those policies, and it's up to the user to to read them and say, actually, I'm not happy with you using my data. And that's under GDPR, that's not obviously the right way, but they'll do proportionality, they'll look at legitimacy, blah, blah, blah. That's in terms of copyright, it's a bit of a blurry line at the moment.
Thanks so much, Ellen. Before we dive in deeper, I'd like to take a moment to tell our listeners a bit more about Prezi. Prezi, we are specialists in communications, helping organizations achieve their commercial objectives, whether that's raising their profile, boosting revenue, or attracting new clients and investors. We combine traditional PR and public affairs engagement with marketing and content-led strategies, focused on delivering the outcomes our clients need, not just ticking boxes. Now, Ellen, how quickly have we seen AI change the world of IP law? And when I mean world, I mean, how are different countries or regions looking at AI in sort of copyright and IP differently to others?
It's definitely an international issue. I think that even, I think that's something that people are seeing. It's constantly in the media. But I think interesting your choice of wording to say how AI has changed the world of IP. I think right now we're sort of at a big climax. That AI has been around and it's been rumbling along, and that interaction with the grey line between IP and copyright and AI and the rights that they've got, and balancing that has been rumbling on and it's been advancing. But I think the explosion came with ChatGPT. Everyone then woke up and realized, oh, actually, Joe Blogs knows about it. And then that meant that legislators had to start getting involved. I think there's obviously political things as well that are a factor. And that's also influencing why policymakers are looking at the, balancing AI and copyright. There's a lot of money, both from a tech perspective and also from the creative industry. So I think we're seeing a lot of lawsuits. And again, I think that's also something that's made a big difference to this world. We're trying to get some clarity through the courts. We've seen loads of cases in the US, and the recent one being Thomson Reuters, the partial summary judgment, and the fair use doctrine in that case is not a legitimate defence, which was a bit of a shock. Now I think it's very fact specific. I'm not saying that they've ruled out the defence of fair use, but it is something for people to be aware of. We're obviously in the UK waiting for the Getty Images. Europe, you've got the EU AI Act, and they've with the amendments after the ChatGPT event or explosion, they then were like, okay, actually we need to look at copyright. So I think it's all come in the last, I'd say in the last year to 18 months, that the two to get together, tech and copyright, have just blown up globally. And obviously the role of China, and also sadly the wars that we're seeing, especially in Russia and Ukraine, and how technology is used. You've got, again, like come back to deepfakes briefly, but these are all things that have sort of brought everything to the forefront and really changed the world, that's made legislators have to start looking at the topic of AI and copyright a lot more than they probably ever thought they would have to. They probably didn't. They thought they were like, really, is this like a geopolitical issue? But now it is, because it's affecting people globally.
Yeah, and globally it's a fascinating, sort of way to take this. And I guess, bad actors, in other words, naughty people using it in a naughty way, always going to be naughty people using it in a naughty way. But if you're a business and you are tempted to rip you off and to give fake legal advice, jurisdiction matters, right? I mean, so they could go and to the lawful South Pole and create a spoof video of you. When does it come into copyright law? I mean, if they just keep it in the North Pole, they're probably okay. But if they start using it in the UK, but if their servers, just to make it really complicated, are in the North Pole, does that mean they can just use it in the UK, or does it matter what platforms they're using?
It's a really good point, and I think especially when you mention platforms, because of the fact that the internet, for example, is global. We're all global. We're all interacting on a global level. Companies are now international. Even a small company will have maybe their manufacturers in China, that the offering it to clients only in the UK, but they'll have a global platform, but it will be geo blocked, or all these different things. So it's a really interesting topic, and I think this is often the issue, because copyright is territory specific. So there has to be a link with the country that you're trying to enforce the law in, and there is an element of harmonisation under the Berne Convention, but it is a complex one. And I think that's, this is a very pertinent issue in the Getty Images case. So around, how did they manage to bring it in the English courts? And I think this also goes to the point of what the government was saying in the consultation, is they want AI developers to come and start developing in the UK, and therefore they need to amend the current copyright law to make it more tech friendly. But it's a really difficult one, and it depends on where the tenuous link is in order to have grounds to bring the claim. But there is an element of harmonisation, especially Europe and US and the UK. There is a general basis of copyright law that we are sort of consistent. Although Europe is civil law and ourselves and the US are common law, but there is a general principle based copyright law that does sort of filter through, that we're all consistent on what our views are and that protection. So I think that in itself is at least some sort of comfort for people, that if they've done it in a jurisdiction in some of these main countries, there is at least some protection of the copyright holder. It's the exceptions, I think, that causes the grey area.
And some of our listeners, like, be small ads companies, social media content creators, or they could be a marketing director, a company, or even a business owner, wanted to really, sort of take their marketing and their content to the next level. And AI has made it so much easier to make really engaging, good content, and it's a positive. It's good. So what are the things business owners need to think about when they are looking at these libraries and using images, using music, using videos, and with things like the AI Act in the EU? Now, many business owners don't probably realize if any bit of their AI tool touches the EU, they're subject to that act and could be liable. Yeah. So there's lots of things they need. Even these tools are great and new, there's some legal things they need to think about. So what sort of advices would you give to laymen as well?
I honestly would just say, look at your liability and indemnity provisions, because if you're signing up to use a tool, a third-party tool that's got AI, check what you're liable for. So is it that if somebody comes along and says, a third party claims that you've used a tool that's infringing their IP in some form, what is your right? Is it that the company who has supplied you the use to that tool, giving you a blanket indemnity? Then great, but also check small print, because it might be that they'll give you an indemnity provided you comply with certain steps. So I think that was Adobe done that, for example, and Microsoft Copilot, maybe they've given an indemnity, and I think it's becoming much more business market practice for them to give you an indemnity. So I wouldn't be surprised if that's something that you will see, but I would just make sure whatever you do, read it, and if you've got questions, just put them in bullet points and send them to your lawyer. And it won't take very long. They can just say very quickly, you're fine, or push back on this, or, because it might be that you can't negotiate it, but then it's a question of evaluating the risk to your company. So it might be that you can use it generally within the company, but certain teams, the risk will be a lot greater. So they'll say, you might want to say, right, this team can't use the tool for this because, for example, they might have access then to confidential data, and therefore you don't want to go into that risk level. But yes, I would just say check contract.
And to flip it, I guess, in a way, or it actually sits together. But if you are a content creator, and we spoke a bit about the typos, but what other protections you should be looking to do? I noticed that I don't know what it was, music artists, music creators, let's call them. YouTube has a special code or something like that. It's above my technical knowledge, which means that when someone uploads a piece of music, YouTube can scan it and it has a footprint. Is it these sort of measures we're seeing now become more common and taken away from professional, musicians? You or I just playing around on TikTok and we're creating a video or something like that. Is there ways we can protect, those sort of images so it doesn't get used by companies or people we don't want to use?
There is always putting disclaimers or some sort of if you can put a watermark, or they can always be removed, but if you can do some sort of labeling, or as simple as putting copyright 2025 label at the bottom, and putting people on notice that this is your intellectual property, that you don't want it to be used. You'll often see even on websites, they'll have a T's and C's, and they'll say, this cannot be, and this can be used for non-commercial purposes. I think by trying to put labels on it and protect it, then you're at least able to come along and say, look, I put you on notice that this was my content and I don't want it being shared.
Thank you so much, Ellen. I've been Nick Connor, and you've been listening to The Communicators, an interview series by Prusy. If you have any question for us or Ellen, drop us a line in the comments. And please don't forget to give this a like. Be sure to tune in next time.
Thank you.